if I can start with some introductions. So Neil and I are partners in Brodie's planning team, and we're delighted to welcome our guest today, who is Robert Seaton, Principal Reporter at Scottish Government's Directorate of Planning and Environmental Appeals, or DPEA as they're often known. So welcome, Robert. Just a few housekeeping rules. First of all, everyone's camera and microphone should be automatically set to off, but if you do have any administrative or IT issues, then you can speak to a member of the Brodie's team in the chat box at the bottom of your menu, and hopefully you'll get assistance with that. So we'd like the session this afternoon to be as interactive as possible. So can I encourage any questions that you'd like to raise? You can do so in the Q&A box at the bottom of the menu. Any questions that you do input there won't be broadcast to the other webinar guests. They'll just be visible to us as the hosts. But can I encourage you to include your name with your question, and we can then come back to you later with an answer if there isn't time to get through all the questions during the session. I should say, if you do include your name, I'll assume that you're happy for me to mention that during the session, so you'll get a shout out. But otherwise, if you'd rather be anonymous, then of course you can just mark your question in that way, and no names would be mentioned. I'll try to pause during the session to bring in questions which are relevant on the way through, or we'll pick up any remaining questions to the extent that we have time at the end. So lastly, before we kick off, I'll just make clear that we are recording this session, and the recording will be available for you to look at afterwards should you want to do that. So I think I can just hand over now to Neil, who is going to have a chat with Robert. So over to you, Neil.
Thanks, Karen, and welcome, Robert. I'm enjoying the fact that I can now ask you questions instead of the usual where the reporter gets to ask the lawyer the difficult questions and we have to try and come up with the answers. I thought it would be useful to start just discussing a bit the role of the reporter, because it's a bit of a mixed audience. Some people will be very aware of what reporters do. So as a good lawyer, I thought I'll go to official source material. According to the Directorate's guidance, the reporter is described as the representative of the Scottish Government who will consider and in most cases decide the appeal. And we can talk a bit about maybe later on the cases where you don't actually make the decision, but the majority of the cases reporters do make the decision. The law actually says that's final, subject only to legal challenge. That feels as though it's quite a heavy responsibility. How do you take that on board? I mean, prior to becoming a reporter, you were a lawyer in private practice. Do you find it difficult now because you're the decision maker and you do have that responsibility?
Yeah, we'll perhaps come on to the sort of lawyer background in a wee bit. Just in terms of the responsibility, yes, I mean, being a reporter is a really unique job. It's I don't think there's many civil servants who get that degree of discretion to exercise ministers' powers on their behalf. And of course, in terms of what permission means to people, of course, it can mean an investment of millions of pounds. It can mean changing the face of a city or a country, or in any area in the countryside. But even small developments to come before us can be very important to people. They can be the embodiment of someone's dream, or potentially in the case of an objector, or in the case of enforcement action, the embodiment of someone's nightmare. So it's yeah, I mean, the stakes can be very, very high for people. And of course, when cases reach us, they tend to reach us at the end of a process in which people have already invested time and potentially quite a lot of cost, frayed nerves potentially. So it's very important, I think, that we address these kind of cases, address cases that come to us with care and sensitivity to the parties who are coming to us, and of course, fairness and transparency about how we act. And of course, the other aspect of it is, I think it was Tim Bryan, who's now retired, said to me, it's judgment that it's all about, and that's what it is. It's huge trust placed in your judgment as an individual to deal with these kinds of issues, the huge issues that come before you. So I mean, it's certainly a fascinating job, but you do, before you press click and send on the decision, you do feel the weight of the responsibility for that decision, certainly. So you also mentioned legal background. So should I go on to that and just
yes.
maybe talk a wee bit about that? Yeah. So it's worth maybe taking a step back from that question and just mentioning that, I mean, reporters aren't, you might assume that reporters are all planners, come from a planning background, and that a lawyer is a bit of a surprise. There's actually 3 lawyer reporters at the moment. Francis McCartney and Trudy Craggs are also lawyers, but reporters come from a range of backgrounds. So there's environmental specialists, there has been an engineer in the past, there's surveyors, there's been architects as well. So there's a range of people, and I think that diversity, as well as planners, and the planners come from all kinds of areas. So they come from central government, local government, from private practice, and so on. And from different areas of planning, from development planning specialists, development management specialists, people who've dealt with a lot of enforcement as well. So there's a real diversity amongst reporters, and I think that's that's a strength, and it comes out in the kind of we obviously have monthly meetings, we swap experience and so on at those monthly meetings, and that's very helpful to be able to draw on other people's experience. But I suppose the other, having said all that, the other people might think, well, is there any kind of specialization amongst planners, given their different backgrounds? And I suppose I think the answer to that basically is, in a jurisdiction like Scotland, it's just not possible to have people specialising in particular kinds of cases. To a degree, that the reporters are divided into, some are employed by the government and some are self-employed and given kind of piecework. The ones who are self-employed, obviously they can choose what developments they can deal with. So there may be a degree of specialism in that. There's no, as I say, I think the policy is essentially to ensure that all reporters could deal with any case, and to bring on the less experienced reporters so that they're able to do that. And I'm sorry, I'm going to come back and actually answer your question, which I think was about being a lawyer and whether that gives me any special insight or background. I think it certainly gives you a particular set of experiences. Obviously, just explain my background a bit. I mean, I was a planning solicitor both in local government and in private practice, and for about, I think, about 11 years before I became a reporter. So I can contribute. For instance, that I represented clients in both, in planning appeal situations quite a lot. So I think there's, I was quite familiar with the process, both of course of inquiries, process of written submissions, and all of that, which is not something all new reporters are familiar with, because I say that they come from a range of backgrounds. I mean, I can also, so I'm able to contribute that. I think there's also I hope I have a degree of sympathy with parties in planning fields. I'm not sure, not saying other reporters don't, but perhaps I feel it most immediately, and all sides, because I've obviously represented objectors and planning authorities as well. I think also that there's a degree to which that there's the kind of technical specialism that a lawyer can contribute. So for instance, I've written the EIA screening guidance for reporters, and dealt with I've written the planning obligations appeal guidance, and done training on written conditions. But I suppose as there's a question of the difference between what a lawyer does and what a reporter does. And I think one big difference from my colleagues in general is that the background I come from is looking to, obviously a lawyer looks to represent a particular interest, whether it's a private interest or a council interest. They want to achieve something in the planning process, and that's so. That with a reporter, you're very much looking at what's in the public interest. So that makes quite a big change, and I suppose that links back to the question of your first question about responsibility, and the degree of responsibility you take on being a reporter. I'm not saying lawyers don't have responsibility, but it's a different kind of responsibility. I hope that answers what you were asking.
Oh, very much. And again, just to give people a bit of an indication of what reporters do, those of us who work in a variety of development sectors know that it's a bit the same for reporters. But just by way of illustration, what sort of range of projects, types of appeal, types of other work are actually on your desk at the moment?
So at the moment, actually, I'm not dealing with decisions at all. I'm dealing with reports to ministers. So I've got a report for two wind farms to do from an inquiry under Section 36 of the Electricity Act, and there's a report on a housing case involving the housing land supply. And various other issues. But previously, I mean, there's a huge range of cases that you can be involved in, and we deal with all kinds of things. And I've dealt with high hedges, the new Queen Street railway station, which I haven't actually been to yet, but so I hope everyone likes it. But we were involved in making recommendations to ministers on that, and I dealt with a new bridge over the Clyde. I've dealt with student accommodation, bonded warehouse, quarries, listed buildings, and all kinds of fairly more minor development as well.
Yeah, which is a fantastic illustration, as we were saying, of the range of work that reporters end up having to do. I thought it would be interesting to talk for a few minutes about how the pandemic has affected the work of reporters, appeal work in general, and maybe just taking it in terms of the various aspects of the procedure for cases that are going to inquiry in particular. Quite often the reporter will have a pre-examination meeting. I think I still keep referring to it as a pre-inquiry meeting, but I think officially it's a PEM.
No, actually, I think we were corrected on that, Neil. I think we were told to. It is a pre-inquiry meeting, and we were told off recently for calling it a pre-examination meeting. So.
Oh gosh, I was right, and I didn't even know it. Wow.
We're thoroughly confused.
Yes, and let's now get on to still talking about reserved matters and outline permissions. So just starting with doing pre-inquiry meetings virtually, I know that's something you've had some experience of. Did you find that was fairly positive. Do you think that's maybe something that could end up being a bit more of a permanent feature, or at least an option?
Yes, yeah, I mean, I certainly think so. I mean, a pre-inquiry meeting is obviously it's an administrative meeting held fairly early on in an inquiry process. You know, you will, as a reporter, have had initial opportunity to examine the case, and you're making arrangements. You've decided there's going to be an inquiry, and you're making arrangements for the inquiry. And it covers things like when and where the inquiry is going to be, who's going to take part, how long it's going to take, what you know, if it's a planning case, what the specified matters are going to be, if it's a wind farm, if it's a Section 36 case, you know, what kinds of procedures you're going to use. So it's very much an administrative thing, and you obviously timetable and so on as well. And I think, yeah, we're becoming quite used to virtual meetings. You know, the kind of administrative business that you deal with at a pre-inquiry meeting is quite, you know, it works quite well in a virtual meeting. You know, there's no examination of evidence that makes things more complicated, and minimal reference to the documents other than an agenda. So I think, you know, as with any virtual meeting, you know, there's a risk of exclusion of people who have poor broadband, or who just aren't technically minded. There's a risk of, you know, of technical difficulties as well, of people just losing their connection. But, you know, because of the kind of administrative business that you're dealing with, you know, there are solutions to that. You can just simply be patient and wait for them to re-establish connection. You can rearrange the business so that it's something they're not involved in can be dealt with, and you can just give them the options to contribute by written submissions if that becomes necessary. So we've actually had feedback from well, a lot of third parties feel quite intimidated to turn up to a room full of QCs where, you know, there's a table set out in front where they're all sitting in a phalanx, and you're maybe sitting in the audience without a table in front of you. There's a kind of equality to a meeting on you know, by virtual means, that I think makes people feel a bit less intimidated by it. So, and of course, you know, the other great aspect of doing it all by virtually is there's a video record of it. So, you know, if our webcasting team is involved, then there might be a video record of a physical pre-inquiry meeting, but it won't always be the case. So that I find that extremely useful, and I'm sure other people do too. You know, and pre-inquiry meetings, you have pre-inquiry meeting for a wind farm. It's going to be, you know, quite often going to be in some place pretty far from people's offices where they may have to stay overnight. You know, they're taking a day or maybe a day and a half out of their schedule for it. It's expensive, and, you know, in dealing with climate change, it's really perhaps not a good idea. So I think virtual meetings are definitely here to stay. The other aspect of it is that it's easier to hold a virtual meeting, and it's easier to hold more of them. So it's possible maybe to have a case conference. I think it's something we're looking at, whether it might be useful to have more meetings in the run up to an inquiry to check things like how parties are progressing with the agreed statements and things like that, and with their preparations for the inquiry. So, you know, I think that, as I say, they're here to stay.
I think we've got quite a few questions being raised by various of the attendees, Robert, interested in the issue around the COVID arrangements. I think we're going to come on to some of these in any event, but Andrew Trigger, for example, has raised a question around the inability to undertake physical site visits. I think that was something you were interested in as well, Neil, and whether there's a risk that may open up decisions to the possibility of challenge. Andrew's making the observation that photos and video footage are all helpful. Obviously, we're aware of councils using those as well in terms of their own meetings, but does it replace being on site is there that ability to fully understand the context. So there's a question there on site visits and
maybe while Robert's thinking about that, certainly I have one at the moment where, because the character and appearance of the area is a key, if not the key issue, the reporter offered to make the decision on the basis of the photos. I'm acting for the appellant, the photos we had submitted, and also Google Street View. And we ummed and awed because inevitably client would actually like a decision rather than having to wait. But we just decided it was just so important when it's character and appearance, and the difference of actually being there rather than using Google Street View and also two-dimensional images. We just decided we weren't prepared to go that far. And the reporter, I think, was unwilling to insist on that, possibly for the reasons that Andrew was alluding to. So I think there is an element there of inevitably, horses for courses and what the parties want. But interested in what Robert's got to say.
Okay. Yeah, I mean, obviously, physical site inspections are, what we would normally do in circumstances, in normal circumstances. But as you say, there is the risk that if at the moment we can't carry on deciding cases because we can't do site inspections at all, then we run the risk of building up a big backlog of cases, not being able to decide things. And it's in developers' interest, it's in council's interest, it's in the public interest to keep things moving through the system. So we do need to find alternatives, and parties do to a degree need to be flexible. That said, I mean, I take the point about potential for legal challenge very seriously. Perhaps planning authorities to a degree might find it easier to take decisions without a site inspection in that particular case because they're more familiar with the area. Reporters tend not to be as familiar with the area. So certainly, where parties bring forward cogent reasons why there shouldn't be a virtual site inspection, I think that the report is generally going to listen to that, and it's certainly where a site inspection involves evaluation of some kind of aesthetic impact of the proposed development, whether it's on a listed building, whether it's on a conservation area, whether it's on landscape and visual receptors, then it's certainly going to make that quite difficult. That said, there are cases where that's not going to happen. So, for instance, I had a case recently which involved mainly a relatively technical flooding issue, and the appellant sent me some drone footage of the area. The council was, I think, reasonably comfortable that the case should be decided without the need for a site inspection. As it turned out, because that was in the previous lockdown, I did have the opportunity to go down and see the site, and I took that opportunity. But I think it could have been decided without. It wasn't absolutely essential that should have happened in that case. I think that there's a couple of examples. I think what there's one. A case in Yetzer Muckert where I think a notice of intention has already been issued, so I can mention that. And there was a virtual site inspection there. It was a housing site, but the main issue wasn't about it wasn't about the landscape and visual impact of the development. It was much more about the number of houses you could fit on the site and the degree to which that kind of the density would affect the character of the village. I understand from a brief look at the case. It's not my case, and in that case, the reporters did run a virtual site inspection that seemed to be quite sensible and reasonably accepted by parties. I don't think everyone was completely happy with it, but I think it seemed to be reasonably accepted by parties in that case. And I don't know if you want me to say anything about the way these things are run, and maybe about the difficulties. I think there are particular difficulties with with Google, and Google is useful, very, very useful, of course. But there are things you have to bear in mind about with it, like the viewpoint that you're given, the kind of view that you're given is the viewpoint is much higher than a person would be. It's a stick on top of a van, generally speaking. The angle of view is much wider than a person would normally have. So these are things you definitely have to bear in mind. I think with that kind of approach, with the approach of we'll maybe get parties to supply us with visual material they want, and then you have the opportunity to comment on that visual material. So we can run a kind of, it's not exactly like a virtual site inspection. It's more like normal evidence that we get, that parties will have an opportunity to say whether they agree that whether that's sufficient, or to comment on whether more ought to be provided. And so that I think that kind of approach works well, as I say, in cases where there isn't maybe aesthetic effects are not the main issue, or whether they're relatively small impacts, like a shutter on a shop or something like that. We've also run site inspections where someone, generally the appellant, has carried a camera around, and others, the reporter mainly, but can direct him where to point the camera, and others can comment on that. And as I say, the Etzemucker case is one example of that. And the other variant of it is that in a couple of cases, a reporter has lived in the area and been able to act for the reporter dealing with the case as the camera person, but there's not much difference there. So does that cover your question? So that's slightly jumbled answer.
Really interesting, and I think yeah, there's really I think it takes the parties to be, I think, realistic and cooperative on these matters, which hopefully we should be seeing across cases, or perhaps not always the case. There was a further question, just sticking with, if you don't mind, Neil, me jumping in on this, but just to let people raise their questions. Scott Valance had raised the question with the rise of virtual inquiries, which I think would be coming on to, just how has the DPEA found dealing with that experience? I suspect you may say challenging, but do you foresee that virtual sessions might replace some of the physical aspects of procedures once restrictions are lifted? So obviously we're talking about pre-exam meetings or pre-inquiry meetings already, but hearings, etc. Anything that we would take out of that we might want to take forward?
Mm-hmm. I certainly think that there is a question of cost, and I think for all parties, a virtual meeting can be much more cost effective than having everyone come to a potentially quite a far away location, and having to obtain accommodation there. As regards actual virtual meetings, virtual evidence is nothing new. Back in, I think it was a case you were involved in, Neil, the unconventional gas case in Falkirk. That involved, I think, cross-examination of a witness in Australia. I think some people have some, some advocates, some professional advocates, have some concerns about, particularly cross-examination in inquiries done virtually. I think they'll talk to you about the body language, or you've seen the body language of the witness. They'll maybe worry about technical difficulties being used as cynically as an excuse to avoid answering a difficult question. I have to say, I don't think that's really been our experience. I think that there are maybe slightly other difficulties that loom larger. For instance, just simply making sure you understand the witness. Even if there isn't an actual technical difficulty in keeping the connection, there can sometimes be difficulties of sound. things peeping, or just so you miss words that are perhaps important. So you have to be a bit patient and make sure that you understand what the witness is saying, understand what the question was as the reporter. To an extent, one common problem is feedback, because people haven't muted themselves, and so in a cross-examination situation where there's an interchange, that can be it can be quite difficult to keep control of that, I think. But it's certainly not insuperable, and I think in that kind of sense, a hearing is much easier to deal with. Document handling, I think, is the big thing, or evidence handling in a hearing or inquiry is quite a big issue. I think one aspect of that for the reporter and for other parties involved is just making sure they're prepared with the right equipment. Having a couple of screens so you can see the witness on one screen and look at the documents on the other is quite an important. It's just one practical way of dealing with it. But I think it's a concern that members of the public might feel excluded if there's that they don't have immediate access to the documents. They can't see the documents that are being referred to. To some extent, that's perhaps no change from a normal inquiry. There's in a normal inquiry there's a set of documents at the back, but how much people look at them, how much people feel able to access what's in them, is perhaps perhaps that's limited to an extent. And in my I did a kind of mixed procedure inquiry with social distancing back in September last year, and the way we dealt with documents there was that we had a program officer, we had screens at the inquiry, and we were able to, when the program officer was able to put the documents up on the screens, and people watching the feed could see the documents. And I think that was actually a very, very useful service to them. And I think actually part of our reason for doing that was because we had a very limited capacity. Even though it was a huge hall we were in, we had very limited capacity to allow people to come to the inquiry, and we basically asked the public to stay away. And I think that was one factor in people not coming in person to the inquiry, was that they really had a quite a good view of it on the webcast. So are they here to stay? I think certainly my inquiry with social distancing was the dealing with the screens, having a program officer to put the evidence on the screens. That was all very, very expensive, and the applicants were offered, and we accepted. They kindly covered the cost of all of that. It's not possible within DPEA's resources at the moment, anyway, to have someone at a webcast putting documents on the screen so people can follow the inquiry in that kind of way, unless someone else is willing to provide that kind of extra function. It may be something that we can look at in the future, particularly, for instance, if planning appeal fees were to come in, that might give us an additional revenue stream, which we might be able to pay for that kind of thing with. There was a bit of there are some technical difficulties as well. I think at my inquiry I think it was quite difficult to read some of the documents because we had a camera pointing at a screen that the documents were projected on. So just for technical reasons, there's some difficulties in just moving from document to person, believe it or not. But it just in that inquiry setting, it was quite difficult. The other aspect of a hearing or inquiry is you can't live stream it if you're having a if you're doing it all virtually, or we can't do it at the moment. We're certainly looking into that. But yeah, I think
sorry, Robert, you finished.
No, as regards whether they're here to stay, I think it's certainly going to be useful for some procedure, just like pre-inquiry meetings. But I think for big inquiries, it's perhaps going to still be preferable just to get everyone together in a room, because it is quite difficult.
And I just wanted to give a shout out for the webcasting, because that's been such a brilliant innovation that was brought in, and I've had so much good feedback from teams I've worked with, you know, the professional teams, as it were, that are able to use it for, you know, a variety of purposes, including, as you were alluding to, being able to watch it afterwards to remind themselves. But equally, members of the public, that I remember a community council person saying the weather wasn't that great, so rather than take the risk of getting the car out in the snow, I just watched it on the webcast. And to me, that's just fantastic that people are able to do that. And okay, we're back to yes, but it's only if they've got a computer and they've got Wi-Fi and we know about those sorts of issues. But I was very interested, was listening to some feedback from barristers in England about doing virtual inquiries, and they were very positive. But one of the things they were very positive about was the webcasting element, because it turns out they've not really had that. So that's one where DPEA have been ahead. But yes, I just wanted to give it a big thumbs up. I think it's an incredibly useful aspect. Maybe then just moving on, and we can pick up some more questions at the end. I was just wondering if you could maybe share for the audience any top tips you might have for people involved in appeals. I mean, we're all familiar with, this is the old-fashioned version now of watch the reporter's pen, and if they stop writing, shut up, and if they fold their arms, seriously shut up. I'm not sure what the modern equivalent now that reporters have laptops is, but I imagine it's the, you know, watch the typing, and the folding arms still applies. And if they fold the laptop away, that's probably a really, really bad sign. But anyway,
mutes you.
Maybe that's right, the screen goes blank. Yeah.
Well, true. But yeah, have you got any tips you could give to people, possibly people who haven't done much in the way of appeal work and are still fairly new to it?
Yeah. I did do a quick straw poll of reports, because I think you mentioned you were going to ask something like this. So the one thing that everyone came up with was focus on the issues, focus on the planning issues. Unless you're making a claim for expenses, don't waste your time telling the reporter how bad the behaviour of the other party has been. It's just not relevant, and the reporter's not interested. I think there's a few others though. That people mentioned. Remember, the reporter isn't an investigator. I think is quite important too. So, you know, if you put a point, you don't just mention it. You need to provide the evidence for that too. Another aspect of it is that if you're, you know, if you have a technical specialism, if you have a technical point, you can't assume that the reporter is necessarily going to understand that. You know, you really need to explain it as you would to a you know, reasonably informed layperson. Hopefully, reasonably informed layperson. I think there's another aspect of presenting a case. I think you have to acknowledge the weak points in your case. This happens all too often, that people ignore that their case may have some weak points. You acknowledge weak points and deal with them. And that, if you take that kind of approach, it makes it much less likely that the reporter is going to have to come back and ask for additional information on those points, because, you know, if the reporter doesn't spot them, the other side will. I think another thing is just read and understand what the other side say and respond to it. That's, I suppose, is another aspect of that. You know, again, you don't want to ignore the awkward points and just hope they'll go away. and I suppose some more minor ones. If you're producing a document, number the paragraphs in it, number the pages. That's always very useful. It makes it much easier if things go to hearing or inquiry. Proofread your submissions is a good one. And witnesses and lawyers, please speak into the microphone as well. Is very helpful. Particularly in virtual sessions where you get people looking at their papers and you suddenly their voice disappears. And I was also asked by colleagues to remind planning authorities to do EIA screening, mainly because we have to do it if they don't do it, and it doesn't put anyone in a good mood. So
I think that's like gold dust from Robert there. I'm conscious of the time, but we have had quite a few questions come in, Robert. Obviously, we're trying to pick up a few of them as we go. Andrew Woodrow had raised a question just around, obviously we've spent some time discussing it, virtual inquiries, etc., but thinking of non-COVID times and the move towards written submissions, obviously as a result of reform some time ago, with far fewer actual hearings and inquiries these days. And I suppose Andrew is really asking for your perspective on that, and how do you find the processes compare? And I suppose, do you in any way lament the sort of falling away in the numbers of the oral sessions? How do reporters find the quality of the evidence maybe that they're getting as a result of that change?
That's an interesting question. I mean, I think it's now just more than 10 years, isn't it? It's about 10 or 12 years since the new system came in. And I guess I was still quite a rookie at that time as a lawyer dealing with the system. But we did have, and the system was great if you enjoyed inquiries, because people would, the parties, the planning authority or the appellant got to insist on the method of determination that they wanted, so they could take it up to an inquiry even for quite a small development. Now I remember doing an appeal for a 13-house development, which was great if you're learning the ropes as a lawyer, but it's not the most efficient way of dealing with development. I certainly think that the new system allows the reporter to focus in on what the key issues are, as long as they're presented well by the parties. But also, there's an incentive in the system for people to put their best case forward in their written submissions, because they don't know at the outset whether that particular written submission will be their last opportunity to say anything on the case. So it's a real incentive to focus the issues. I think if there are perhaps risks with it, the risks that I see sometimes are, I sometimes feel that the 28 days that someone who served with an enforcement notice gets to respond to the enforcement notice feels like quite a short period if they have to produce a full response, a full appeal with all the evidence that they need to respond to it. So do keep an eye on those kinds of cases. And I suppose the other aspect of it is where a planning authority, that has refused an application against the recommendation of their planner, and that's been appealed. The 21 days that the planning authority gets from the appeals feels like quite a short time to prepare their full case again. And I think planning authorities, quite a lot of planning authorities, have internal mechanisms to deal with that, so the case doesn't go back to the planner who recommended approval to say why it should be refused, which would be quite wrong. A lot of planning authorities have particular appointees, or in Fife it goes to the lawyers. I know because that's where I dealt with them. As I say, I think the system is a great gain for efficiency, and certainly it doesn't. I hope people don't get less justice from it, or feel they get less justice from it.
And Robert, a few questions have been raised along a similar theme, so I might just group these together. So we can give a shout out to David Bell, John Kelly and Ian Cowan, who have all raised a sort of a similar issue and that's around the consistency of decision making amongst reporters and consistency. I'm getting distracted by a telephone going somewhere. Consistency of decision making around for reporters and the possibility of peer review. And so the question is asked, is it the case that reporters will, one reporter will peer review another's decision perhaps before it goes out the door, and what checks and balances might there be in relation to consistency on similar issues, whether there are
there is a degree of peer review. There's various ways that we do it. We've had a system annually where reporters have looked at each other's decisions. So in that sense, you picked one decision and taken a look at it and commented on it. And that, it feels like quite a brutal process, but everyone's, and reporters being reporters will be quite objective about it.
Objective,
not necessarily, being nice to you. There's also for new reporters the system mentoring. So generally speaking, their decisions won't go out unless they've been looked at. Not to tell them what to decide, obviously, and could be entirely wrong. But just to read it for consistency, to check that they've addressed what parties are saying, that they're not getting things legally wrong, and so on. Just because not everyone is as familiar with the system to start off with, and yes, there's I think that there's a system of marking both for by management for reporters, again looking at particular individual decisions that have been made during the year, and just checking them. That feeds into for employed reporters, that feeds into their sort of job evaluation, their annual sort of job appraisal, and for self-employed reporters that feeds into an appraisal of how they're doing as well. Yeah, so hopefully, and also in terms of general issues, they do get discussed at management level. Things are, there is discussion about how to the degree to which cases can be consistent. Obviously, we're not independent decision makers in that respect. So, and there's a requirement for us to be consistent. So it's really a matter of making sure that new issues are drawn to reporters' attention to make sure they know about how other reporters have decided them. It doesn't stop you from disagreeing, but I think you have to make sure that if you're disagreeing with another reporter, you have very good reasons set out as to why you're disagreeing.
Well, that's very helpful. I suppose following on from that, and this may or may not be something that you're conscious of or have a view on, Robert, but Tim Stott has asked the question whether you think that judicial reviews of reporters' decisions, so statutory appeals perhaps, are increasing, and if true, would that influence reporters rather to reach more conservative decisions?
It's a very interesting question. I don't have the statistics to say whether they're increasing or not. It feels like they've been quite a lot recently, but whether that means they're increasing or not, or just becoming more sensitive to them, I don't know. I
suppose, would you say it plays on, does it play on the mind of a reporter when he or she would be writing up their decision, the prospect of a challenge if it's known that an issue is controversial?
Yes, to an extent. I mean, I don't think it would play on your mind. I think maybe a bit more for me because of my background, and perhaps I'm a bit. I suppose in terms of style of writing decisions, I do think about that's perhaps just a legal thing. You think about the what ifs and the even if sort of arguments. But I don't think judicial reviews happen often enough for reporters for them to be intimidated by them or to hold back on granting permission. I think that goes back to that responsibility thing. I think deep reporters feel already feel the responsibility to make the best decision they can. So yeah, and I don't think we fear the courts in that way. No, I hope not.
Okay, well, coming back to that, I guess that question of responsibility, it's maybe just a good point to pause and sort of draw things together. I'm just conscious, I think we could be talking about these issues all day, and I think the questions would keep on coming, but conscious of your time, Robert, and everyone else's who has been listening. So I think a fascinating insight into the life of a reporter and what's been going on at the DPEA over the last year, and the challenges through recent times with COVID, which I think we can all sympathise with, and everyone, I suppose, has been grappling with from their different part in the system. But it's certainly encouraging to hear what's been working well, and perhaps some of those good things that might be taken forward into the future once we're all back on a bit more of a normal footing. So I think it's a big thanks from us, Robert, to you for joining us this afternoon. It's been great to talk to you, and I think really interesting. It certainly brokered a lot of interest from the attendees, and I think we'll be able to share with you some of those questions that we've not got to this afternoon.
Right.
There may be an opportunity for us to follow up with people in that way. So thanks very much for your time. It's been really
Thank you.
good to have you on the session.
Yes, very
Karen,
interesting. Thank you. Yeah.
Sorry, someone on the chat was just asking, the recording will be available via our website probably in a few days' time. I suspect Robert won't rush to listen to himself. If he's anything like me, I hate listening to myself. But yes, it will be there, so that if you want to pass it on to colleagues or have a listen again yourself, it's there for use.
Thanks, Neil. That's super. So really just remains for me to say that our next planning live session will be on 8th April. There you have it. And we'll be delighted to host Barbara Cummings, the outgoing Director of Historic Environment Scotland and convener of the RTPI in Scotland. So I think there'll be lots to talk about on that occasion. So I hope you can join us at that session. And thanks again, everyone, for attending today and for your contributions. So it's over and out at this end. Thanks, everyone.
Bye.
Bye.